Ready, start. The presumption of fact with regard to the demand and acceptance or obtainment of an illegal gratification may be made by a court of law by way of an inference only when the foundational facts have been proved by relevant oral and documentary evidence and not in the absence thereof. Full stop. On the basis of the material on record, the court has the discretion to raise a presumption of fact while considering whether the fact of demand has been proved by the prosecution or not. Full stop. Of course, a presumption of fact is subject to rebuttal by the accused and in the absence of rebuttal presumption stands. Full stop. In the event the complainant turns double inverted comma hostile double inverted comma close comma or has died or is unavailable to let in his evidence during trial, demand of illegal gratification can be proved by letting in the evidence of any other witness who can again let in evidence, either orally or by documentary evidence, or the prosecution can prove the case by circumstantial evidence. Full stop. The trial does not abate nor does it result in an order of acquittal of the accused public servant. Full stop. Insofar as Section 7 of the Act is concerned, on the proof of the facts in issue, Section 20 mandates the court to raise a presumption that the illegal gratification was for the purpose of a motive or reward as mentioned in the said section. Full stop. The said presumption has to be raised by the court as a legal presumption or a presumption in law. Full stop. Of course, the said presumption is also subject to rebuttal. Full stop. Section 20 does not apply to sections 13 within bracket 1 within bracket D within bracket first and within bracket second of the Act. Full stop. We clarify that the presumption in law under section 20 of the Act is distinct from presumption of fact referred to above in subpara 88.5 within bracket E, above, as the former is a mandatory presumption while the latter is discretionary in nature. Full stop. It has been categorically held by the Constitution bench that the proof of demand and acceptance of illegal gratification by a public servant is a fact in issue in the criminal proceeding and is a sine qua non to establish the guilt of the accused public servant under sections 7 and 13 of the Act. Full stop. Unless proof is offered to the satisfaction of the court that there is a demand and acceptance of illegal gratification, the presumption would not arise. Full stop. The presumption under section 20 of the Act cannot arise on the mere allegation of a demand and acceptance of illegal gratification as rightly pointed out by the appellant. Full stop. The question of presumption does not arise in the present case where the special court had merely examined the complainant and also summoned three witnesses, the officers of the investigation team, under section 311 of the CRPC for the purpose of recording their statements. Full stop. This is pre-charge evidence based on which summons have been issued to the accused numbers 2 to 7. Full stop. However, even a prima facie finding has to be on the basis of allegations containing definite ingredients for which proof could be offered at the trial, giving rise to the presumption under section 20 of the Act, which presumption is also rebuttable. Full stop. Immediately, we come to the judgment of High Court, which specifically looked at the earlier judgment in the special criminal application filed by the very same appellant. Full stop. It is clearly indicated from paragraph 68 of the earlier judgment that the learned single judge, while finding no ground to interfere with the rejection of the discharge application at that stage, noticed that the pre-charge evidence is being recorded by the special judge, at which stage also the accused will be entitled to cross-examine the witnesses, and on conclusion of such recording of evidence, if the writ applicant so desires or is of the opinion that no case is made out, he could prefer an appropriate application for discharge under the provisions of section 245 of the CRPC, full stop. This clearly left liberty to the appellant to once again seek discharge if there is no material found from the evidence recorded, full stop. Hence, we do not think that the opinion expressed by the learned single judge that the petitions are required to be dismissed, since at the earlier point of time the High Court had found a prima facie case made out against the accused, is correct, full stop. Earlier, there was the allegation coupled with the fact of the grants having been made, without a tender process, which also stood cancelled by the High Court, and there was no worthwhile investigation carried out, full stop. At this stage, a detailed report on investigation is placed before court, and the officers who conducted the investigation, examined too, full stop.